we're a few minutes behind, so I'm just going to start the panel without further ado. But once we had the reference the Impact Assessment Act, we knew we wanted to assemble some of the best constitutional environmental law scholars and come help us work through this case. So we're going to begin with Anna Johnston, who is here from West Coast Environmental Law. Then we're going to turn to Deb Curran, who is there joining us online. Welcome to you, Deb, who is at the University of Victoria. And then we'll turn to my colleague, Dayna Scott from Osgoode Law School, and we'll end with Nathalie Chalifour from the University of Ottawa. So without further ado, Anna, over to you.
Good morning, everyone. Am I on? Great. Great to be here. Thanks so much for the invitation. And thanks to the organizers for this opportunity to speak. So as Emily noted, I'm a staff lawyer at West Coast Environmental Law, and I was counsel for two of the interveners, West Coast Environmental Law and Nature Canada, in the case before the Supreme Court and the Alberta Court of Appeal. So I'm going to be framing my comments on the case today through the lens of what we argued before the court. Because I'm going first, and to make sure that our sort of respective analyses of the decision are grounded in an understanding of both the legislative scheme and also the case itself, I'm going to begin with a brief overview of the Impact Assessment Act and then a high-level overview of the majority's opinion in the case. I'll then do a deeper dive into what the majority said around decision-making and explain why I think they got it wrong. By giving an example of looking at a Mines effect through a gender-based analysis plus lens. And then I'll give my thoughts on where I think federal decisions can go from here following impact assessments, and what I think is a missing piece in the majority's analysis around the distinction between what you consider when you make decisions and then what you do with that information following the decision. And then I'll wrap up with some conclusions. So the Impact Assessment Act is Canada's fourth assessment law. It's an information gathering and planning tool aimed at understanding and avoiding and mitigating the adverse effects of projects before they occur and enhancing their benefits so that decision makers can make more informed decisions about whether and under what circumstances projects should go ahead. The Impact Assessment Act is designed to really only apply to major projects. So that amounts to approximately 10 to 12 projects a year that have been considered to be the projects with the most potential for the most significant adverse effects on areas of federal jurisdiction. That's a change from 15, 20 years ago. We were assessing thousands of projects a year. The projects under the Impact Assessment Act are designated either in regulations according to their type and size, or by a discretionary decision by the minister following a request from a member of the public or an Indigenous nation or community. The Act requires assessments to consider a broad range of factors, 20 different factors: environmental, social, economic, health factors. And at the end of assessment, either the minister or governor and council, as the case may be, must decide whether the adverse federal effects are in the public interest. So a 5-judge majority of the court, led by the Chief Justice, held that the main designated projects scheme in the Act, so that's the scheme I just mentioned that applies to those projects that are designated in regulations or by order of the minister, is unconstitutional. There is a second scheme in the Act that applies more minor environmental assessments to projects that occur on federal lands. The court held that that scheme is fine. It's just this main scheme of the Act, the designated projects scheme, is unconstitutional, and the majority found that its pith and substance is to assess and regulate designated projects. So that's important, right? It's not to assess and regulate the federal aspects of designated projects, but the projects themselves. It did confirm, while it held that this scheme is unconstitutional, the majority did confirm that the federal government can enact comprehensive legislation to assess major projects, so long as its dominant characteristic is aimed at federal matters, and this law, it found, was not. I'll get into the reasons why not, but first I just want to point out that the majority did give some fairly good affirmations for the federal government around its power to assess projects and activities. First, they rejected the main thrust of Alberta's arguments that interjurisdictional immunity should shield projects from federal review. And also Alberta was arguing that the feds shouldn't be able to say no to the adverse federal effects of natural resource projects. The court said, no, the federal government does have jurisdiction, as I mentioned earlier, to enact impact assessment laws and to subject natural resource projects to those processes, so long as those processes are aimed at the federal aspects. It upheld the project list approach, which was one of the bigger questions at play in the case. So designating projects and regulations is constitutional. And in fact, the majority found that the jurisdictional threshold for triggering assessments is low. You only need the potential for adverse effects. You don't need proof of federal effects. And then it also upheld the broad scope of factors that can be considered in assessment, so that that range of 20 social, environmental, economic, health effects, there's no constitutional limit on what can be considered during the assessment. So why was the act unconstitutional? There are two fundamental reasons. The first is that the majority found that the definition of federal effects in the act is overly broad, in particular, the way Parliament asserted jurisdiction over greenhouse gas emissions and also over impacts on Indigenous peoples. And I believe Nathalie and Deb are gonna go into more detail on those two aspects, so I won't focus on them. There's a related issue from the definition of federal effects that it also means that the prohibitions prohibiting projects from doing anything that would cause federal effects, that's also too broad because it's based on the definition. And the second main issue that the majority found was that adverse federal effects don't drive key decisions in the act. And those two decisions that were of issue are an initial screening decision after a project is designated, approximately 90 days into an early planning phase. The Impact Assessment Agency of Canada has to decide whether an impact assessment is actually required. The majority found that that project isn't driven by the potential for adverse federal effects. And then also the final public interest decision. And that is the aspect of the case that I'm going to focus on here, what the majority said around public interest and why I think it's problematic. So I mentioned that the minister or cabinet has to decide whether the adverse federal effects are in the public interest. Under the act, they have to decide that in light of the impact assessment report, which includes all those 20 factors, and 5 additional enumerated factors, including things like the extent to which the project fosters sustainability and the extent to which it helps or hinders Canada's ability to meet its climate commitments. So according to the majority, the fact that those considerations relate to the project as a whole opens the door to the decisions being about the project as a whole, rather than just being about the federal aspects. And the majority said what federal decision makers can consider when making decisions varies depending on the type or category that the relevant head of power under which they're making their decisions falls into. So, for example, provincial jurisdiction over mining, according to the majority, would be considered to be in relation to an activity, whereas federal jurisdiction over fisheries would be in relation to management of a resource. And just to back up a little bit, in Old Man River, which was the last Supreme Court of Canada case on this issue, Justice Chalifour held that it's unhelpful to categorize projects as being primarily provincial or primarily federal in nature. In the Impact Assessment Act reference, the majority acknowledged Justice Chalifour's comments, but then went on to say that jurisdiction still may be classified in these two different ways, and in effect established a hierarchy of powers, giving supremacy to activity jurisdiction with natural resource or resource jurisdiction falling secondary. So what the majority held was that where an order of government's jurisdiction is over activities, there's no constitutional limit on what they can consider when making decisions. So if the feds are reviewing a railway, for example, they can consider whatever they want when deciding whether or not the railway is in the public interest. But when the feds have resource jurisdiction, they're more limited in what they can consider. And in particular, they can't consider the non-federal adverse effects. They can consider provincial benefits, but they can't consider provincial adverse effects when deciding whether the federal effects are in the public interest. I'm going to diagnose or get into that, I'll critique that a little bit in a second. But first, I'll give an example from the majority's reasoning just to hopefully make this a little bit clearer. So to demonstrate its rationale and how it would play out in federal decision-making, the majority turned to the double aspect doctrine using the example of a mine. And so a mine may be regulated from the provincial perspective of the province's exclusive jurisdiction over natural resources, whereas other aspects like its effects on fisheries and navigation may be regulated by Parliament through that federal perspective, right? So where the feds, and I mentioned before, have natural resource jurisdiction, the scope of information they can consider would be more limited. So according to the majority, if a federal decision maker concluded that the project, that this mine project would contribute to sustainability, it could factor that consideration into decisions about whether to turn a lake into a tailings pond. That would be constitutional because it would still be about the fisheries. But for reasons that it doesn't explain, if that same decision maker were to conclude that the project would hinder sustainability overall, it couldn't consider that sustainability determination because if it did so, and now I quote, the thrust of the decision and the force of federal regulation would no longer be driven by the fisheries aspect of the mine. Rather, the fisheries aspect would have been subsumed into consideration of the project's overall sustainability. So I may not need to, but I'm going to highlight a few troubling aspects of the opinion. First, I think creating a hierarchies of jurisdiction, activity versus resource, in my view, is constitutionally arbitrary, other than some slight sort of indications of and pushback from Justice Lafferay and Oldman. I haven't seen it elsewhere in environmental constitutional cases. And I think it's likely based on an ideology that natural resource extraction and economic gains trump environmental issues and protection. Second, distinguishing between positive and negative aspects of matters, I think is also constitutionally arbitrary. Whether an impact on fisheries is positive or negative, it doesn't change the fact that it is still in relation to fisheries. But according to the majority, federal jurisdiction is only over that negative aspect. And third, and this is where I'd really like to dive into the decision, it ignores the fact that decisions have consequences and decision makers ought to be responsible for those consequences. So to illustrate my concerns, like I mentioned earlier, I'm going to talk about the implications of the opinion through the lens of intersectional effects on various identity factors. So there is a requirement under the Act to consider the GBA plus gender-based analysis plus the intersection of sex, gender, and other identity factors. If we go back to the majority's example of a mine, one that, let's say, will turn a lake into a tailings pond, doing so would require authorizations under the Fisheries Act and the Canadian Navigable Waters Act. It'll impact Indigenous peoples, impact migratory birds. Like there are clear federal jurisdictional hooks. Let's assume that this mine will also result in a whole lot of jobs, like 2,500 direct and indirect jobs, which is not unusual for a mine in Canada. A lot of those jobs might be filled by people coming from out of town, many of whom might be accompanied by their families. So in other words, we're looking at a couple of choices, either to house everybody in camp, or what often is the case, people end up, especially families, end up living in town nearby. And so when we get big influxes of populations, what we know, especially largely male populations in communities, which are often small, can lead to things like increases in housing prices, decreased housing availability, pressures on healthcare services that are now overwhelmed, that local governments don't have the capacity to beef up, increases in intimate partner violence and addiction, increases in teen pregnancy and sexually transmitted infection. And who is predominantly affected by those changes? Mostly women, mostly people of color, mostly people with disabilities, mostly older people, mostly Indigenous peoples. So all of those impacts would be things that would be flowing from the decision to allow the proponent to turn the lake into a tailings pond. But according to the majority, the federal government is not constitutionally permitted to consider those consequences of a decision of whether or not to issue a Fisheries Act authorization. to turn that lake into a tailings pond. So where does that leave us? One option is to do as the majority suggests and just ignore provincial adverse effects. A second option might be, that I would argue might be more constitutionally balanced, would be to then just ignore all provincial effects. If you can't look at the provincial adverse effects, then don't look at the provincial benefits like jobs. Of course, what that means is that authorizations would never be issued, because why allow a company, a proponent, to turn a lake into a tailings pond or impact fish or migratory birds unless there's some benefit, and those benefits are almost always provincial in nature. A third option would be to try to look at net provincial effects. So for example, where the proponent is claiming job benefits, you could maybe look at who those jobs are going to go to, the quality of those jobs, who gets the high paid jobs, who gets the skills development to work up the job ladder. But the court wasn't clear on how big that net could be cast. So if the proponent says, hey, look, jobs, can that open the door to considering things like impacts on housing? The majority didn't go into that, but I think based on the decision, the answer is probably no. So that leads us to the fourth option, which is to put decisions back into the black box where they were under the previous legislation, the Canadian Environmental Assessment Act 2012. The majority actually endorsed that decision function, which was whether or not a project would result in significant adverse environmental effects, and if so, whether those effects are justified in the circumstances, with no criteria around what justified in the circumstances might look like. And so in my view, I think none of those are particularly satisfying options, in particular because members of the public and Indigenous peoples who participate in assessments want to know that their concerns have been heard. So I also just want to pause here, and I just have, I think, one more slide after this. In my view, there's a big gap in the majority's analysis, which is the distinction between making that yes/no decision, that public interest decision, and then regulating the project after the decision. So under the Act, if the minister or cabinet decides that the adverse federal effects are in the public interest, the minister must establish any condition that he or she deems appropriate that is directly linked or necessarily incidental to the carrying out of a power or performance of a duty under the Act. So in other words, if somebody has to issue a Fisheries Act authorization following the assessment, then the minister can establish conditions of approval related to the consequences of doing so. And in my view, that's actually the crux of the constitutional, the division of powers issue there. So as my friend and mentor Meinhard Dual used to say, there's a difference between what you consider and what you do with that information. Right. So in other words, there's a difference between considering the broader GBA plus implications of issuing a Fisheries Act authorization on the one hand, and then attempting to regulate housing and communities on the other hand. And that's, I think, what the majority really missed, is that what you consider ought not to be limited by constitutional constraints. What we argued was that it was just like a reasonableness. Is it relevant? Is this factor relevant to the decision or not? Where the constitutional limitation should come in is what you do with that information after, around conditions of approval and permitting. Unfortunately, of course, the majority did not agree with me on that. So this is my last slide. So just to conclude, I think with this decision, we have a step backwards for Canadians and for the environment. But in particular, we have a step backwards in terms of credible and informed and transparent decision-making. At the very least, this decision is a missed opportunity to clarify that line that I talked about between decision-making and then post-decision regulation of projects, which leaves us between a bit of a rock and a hard place. So federal decision makers can attempt to unscramble the egg of like the various interrelations and interactions of effects, or they can put decisions back into the black box where they were under SIA 2012. Either way, I think that's an option that will likely erode public trust in decision-making, particularly among participants in impact assessments who go into processes expecting to have their concerns heard and reflected in decisions. I think it also leaves us with a question around implications for decisions under other statutes that may be less prescriptive around what can be considered in decision-making. And all in all, I think the majority's opinion has enough problems and findings like the ones that I have pointed out and leaves enough questions that we can reasonably expect to be revisiting this issue in upcoming years. And on that very positive note.
Thank you so much, Anna, for that exceptionally sharp breakdown of a very complex reference. So we're going to go to Deborah Curran now. And I just wanted to remind those of you joining us online that I am monitoring the chat. If you happen to have a question, you're welcome to drop it there. So over to you, Deb. Thank you.
Thanks so much, everyone. And I'm hoping that you can hear me all right.
Thank you.
Okay, let me just get my... Okay. Thanks, Anna, for such a fantastic overview and for highlighting some of the concerns with this case. A big thank you to Emily, Sonia, and Ben for accommodating my preference to limit my GHG emissions and to present online. I appreciate that I'm taking advantage of your energy in the room, and hi to Dayna, Nathalie, and Anna as well. It's a delight to be presenting with you. I'm speaking to you from Lekwungen People's Territory here in Greater Victoria, the Songhees and Esquimalt nations, as well as the Wasanich nations, whose relationships with this land and legal orders continue to this day. My perspective comes from in particular, working on environmental law issues for the past 30 years here in what we know as Canada. My work in the Environmental Law Clinic at the University of Victoria, where increasingly we're being asked by Indigenous nations to help them to uphold their Indigenous legal orders in interactions with state law. So I don't work in Indigenous legal orders, but I am helping them to create instruments that are at I guess the confluence between Indigenous legal orders and state law. And also my colleagues in the JD Indigenous Law degree program, with whom I have the privilege of having conversations and exploring these issues. So just starting off with an observation from Anna's submissions to the Supreme Court of Canada, as a majority of this court, this found in the Oldman River case, impact assessment is simply an information gathering and sound decision-making tool. And as an information gathering tool, it must apply early before it may be known whether an undertaking will impact areas of federal jurisdiction. But if impact assessment is simply an information gathering tool, really, what is all the fuss then? And so, as has been somewhat characterized by Anna, in fact, it really is, it mediates this conflict or this conversation between the provincial desire to have largely unfettered discretion to allow natural resource extraction without federal interference. And so I observe that we're coming to the end of this era of unfettered provincial discretion, as the cumulative impacts of extraction and cooperative federalism require a new approach that introduces the concept of ecological limits to conform to Section 35's recognition and affirmation of Aboriginal and treaty rights. And the significant absence from the Impact Assessment Act reference of this conversation is meaningful. And it's meaningful attention to the interaction between the division of powers, in particular federal effects on Indians and lands reserved for Indians, in the context of provincial natural resource extraction and the rights acknowledged and affirmed in Section 35. So as was stated in paragraph 196 of the judgment, I acknowledge that the unique position of Indigenous peoples means that designated projects may affect them differently than other residents of a province, and that by virtue of Section 9124 of the Constitution Act 1867, the federal government is vested with primary constitutional responsibility for securing the welfare of Indigenous peoples, and that's a quote from Delgamuukw. Nonetheless, the scheme's indefinite prohibitions following a negative decision statement or any act or thing that may have an impact on or cause any change to these areas overshoot Parliament's legislative authority under Section 9124. So my final point of introduction is, as Professor Robert Hamilton noted in his October 2023 blog post on this reference, To claim that the federal government can no longer legislate under Section 9124 in a manner that limits provincial jurisdiction is to confuse core and scope, and to read the Tsilcotin decision as not only having limited the application of interjurisdictional immunity, but of paramountcy as well. Such a reading also appears inconsistent with the reasoning of the majority of the Supreme Court in reliance on Section 9124. The problem is the court missed an opportunity to provide a clear answer. So I would like to just note three particular, somewhat in statement, simple things related to the interaction between the Constitution and ecological limits upon which Section 35 rights are based. So the first is that Section 35 rights are based on ecological integrity in many cases across Canada. The second point is that resource extraction, which is within provincial jurisdiction, ultimately prevents the meaningful exercise of Aboriginal and treaty rights over time, so based on cumulative impacts. And then, so what could this mean for future? I've put streams, just giving a nod to my interest in water law, of cooperative federalism. And of course, I don't have any answers there, but it's interesting to think about, especially in light of our consideration of Indigenous legal orders. So turning to my first point, that many Section 35 rights and the Indigenous legal orders from which they flow are based on ecological integrity. And I think this is a fairly simple and obvious point. So, core Section 35 rights are the right to fish, the right to hunt. That requires some functioning sense of an ecosystem. And then, of course, I look to my Indigenous law scholars, our colleagues who have written extensively in this area. And this is one quote from Professor Darcy Lindbergh's PhD dissertation on Cree law. So he's looking at Plains Cree earth law and constitutional ecological reconciliation. And he really notes, he's writing about treaty implementation. So in this case, Treaty 6, and notes how state treaty implementation has prevented attention to ecological integrity that is an inherent part of Cree law and practices of treaty rights. So I won't go further on this point, but there's lots of other things that we can talk about in that respect. The second point is that resource extraction under provincial jurisdiction in some territories disrupts ecological integrity to the extent that it impermissibly prevents Indigenous peoples from meaningfully practicing their Aboriginal and treaty rights. And so really ecological limits restrict provincial jurisdiction for resource extraction because the exercise of Aboriginal and treaty rights requires some element of ecological connectivity and function. And so the example I'm going to give of this is the Yehi v. British Columbia decision. So that's 2021 BCSC 1287. And this is a BC Supreme Court decision that was not appealed by the BC government. And it concerns the Blueberry River First Nation, whose members are of Cree and Deneza ancestry and identify as Deneza. And Blueberry Territory is on what is now called the Upper Peace River District, which is core oil and gas development and industrial extraction area in the northeast of BC. So Blueberry's main reserve community is located near what is now called Fort St. John. And their territory extends over approximately 38,000 square kilometers in the Upper Peace River region in BC. They are signatories to Treaty 8, where the signatories agree that Blueberry shall have the right to pursue their usual vocations of hunting, trapping, and fishing throughout their territory, except as such tracts as may be required to be taken up from time to time for settlement, mining, and lumber. So that's the ability for the province to develop in their area, but they still have guaranteed rights. So in determining the overall scale of disturbance and development in Blueberry Territory from oil and gas, forestry, and agricultural and mining activities by the province, the court relied on evidence, that in 2018, 80% of the Blueberry claim area was disturbed when a 250-meter buffer was applied. and 91% with a 500-meter buffer. So you can see that over a 50-year period, the extent of taking up by provincial oil and gas approvals blanketed virtually the entire territory. And that's a paragraph 906 of the judgment. And so ultimately, the court concludes that this continual approval of industrial development and failing to develop a cumulative effects framework infringed Blueberry's treaty rights, and the province had failed to develop an adequate cumulative effects mechanism that would have adequately acknowledged their treaty rights. And so, whoops, my apologies. I'm clear that I can go back. So I'm just going to briefly say what the declarations of the court were, is that there was a clear breach. There was a cumulative breach of Blueberry's treaty rights. The province had taken up lands to such an extent that there were insufficient and not appropriate lands in the claim area to allow for their meaningful exercise of treaty rights. And the province was prevented from any more approvals until this was addressed. The second example I just wanted to get into briefly and quite recently is Athabasca Chipewyan First Nation has just very recently, about a month ago, filed an action against the Alberta Energy Regulator. And this was where there were about a 6 million liter spill or uncontrolled discharge of industrial wastewater at the Curran oil sands facility. And the nation goes on to say that they were not notified of this, that this clearly had an impact on the lands and waters where their members exercised their treaty rights. And they felt that this, in fact, integrally compromises the members, the Indigenous people who are acting within their territory, as well as not meeting their treaty promises. At the same time, so this was just this week, the same nations, Athabasca Chipewyan First Nation, declared their water policy. So to Betatsene, with water we live. And they note that Treaty 8 establishes a relationship of mutual respect and benefit between ACFN and the Crown promised that ACFN members' land and life would be protected from interference. The Crown hasn't honored these promises, and so the water policy enables the ACFN to protect and preserve the river through Dene laws so that the river lands and way of life can be maintained for future generations. So returning to the inherent ecological limits imposed by the Constitution by virtue of the interactions of Section 92A, Section 35 of the Constitution Act 1982, and Section 109 of the Constitution Act 1867. At a regime, watershed, or territorial scale, what constitutional doctrine serves as the boundary to provincial expression of its ability to permit extraction of natural resources. So, and the delineation of Section 35 rights that have focused on justification of infringement of Aboriginal and treaty rights for the development of Canada and the taking up of lands. So where are these inherent ecological limits upon which Aboriginal and treaty rights exist? And I would argue that this is a constitutional question, not one of environmental administration or management. There have to be some broader principles that redress broader principles than redress for the infringement of Aboriginal and treaty rights being left to claims in nuisance. So now we see nuisance claims where there has been an unjustifiable infringement as per the Athabasca Chipewyan, or for example, the Saikus and Stellatan First Nations in BC seeking restoration of flows in the Chaco River after it was rerouted to power a hydroelectric facility. And so finally, what does this mean for cooperative federalism? Well, I'm sure you have as many ideas as I do. I just wanted to note a few things. So, thinking to the principles about our laws being internally coherent, and as the Supreme Court of Canada has noted, that the division of powers and provincial jurisdiction over natural resources and their extraction cannot harm other constitutional authority or principles. How is it that we can start thinking about ecological limits to the exercise of state jurisdiction in order to uphold Section 35. And given our legally plural Canada and the pervasiveness of Indigenous legal orders, one might start considering a triple aspect doctrine to environmental assessment and more broadly natural resource extraction. So a third aspect are Aboriginal and treaty rights acknowledged and affirmed in Section 35. And this is an image of the Gitniau hereditary chiefs establishing their own impact assessment process for activities within their territory. Meaningful recognition of Indigenous legal orders would require intersocietal government-to-government agreements as expressions of the purpose of Section 35, so that is reconciliation. So we see very recently the Haida negotiated title agreement, and I look to others like the Great Bear Rainforest Agreements, which is 25% of the global coastal temperate rainforest in the world that is protected, and the agreements of 7 nations in the province of BC that is based on an ecosystem standard of returning 70% of that territory to old growth over a 250-year time frame. So at minimum, there's a federal role under Section 9124 for broader consideration of environmental effects as they have a specific impact on Indigenous peoples, and see Professor Rob Hamilton's blog post for further contemplation of this. And so my final point is that ultimately most regional and cumulative effects assessments will implicate federal authority. And I just think of water contamination. So water flowing through multiple Indigenous territories, flowing downstream, will always affect the health, social, and economic conditions of Indigenous peoples. Thank you.
Triple aspect. Thank you so much, Deb, for that very powerful intervention. Over to you, Dayna.
Thanks, everyone. Thanks again for the invitation. I haven't been to con cases in a long time. I am one of these law profs that works on community-based research and very rarely gets invested in something the Supreme Court of Canada has to decide. But this happened to me this past fall because I was teaching the main environmental law course at Osgoode. And, you know, we were there twice a week in the classroom and the students were streaming in with tons of enthusiasm and energy. They're still kind of excited about the Greenhouse Gas Pollution Pricing Act reference, which they see as a win. They have tons of enthusiasm for the idea of climate litigation, for youth litigants that are gonna, you know, sort of right the ship and save the climate, and test case litigation generally. And so in the midst of teaching these students about division of powers and carbon taxes and all of that, we get the Impact Assessment Act reference. And I was also interested in it for another reason, and that is that I've spent many years working alongside the leadership of a small Anishinaabe community in Ontario's far north called Nishnantaga First Nation. And in fact, the students in Osgoode's Environmental Justice and Sustainability Clinic have been assisting Nishnantaga on issues related to environmental assessment, specifically in that case related to proposed roads that are supposed to head to the Ring of Fire. And some of you may know the Ring of Fire, this hyped mineral deposit in the far north of the province that is thought to contain the critical minerals that will help us find our way out of the climate crisis. That part of Ontario also happens to be the largest intact boreal forest remaining in the world, a globally significant wetland, and a massive carbon storehouse. It's also a landscape that has sustained the lifeways of Anishinaabe and Anishinaabe peoples, its sole inhabitants since time immemorial. But the remote Indigenous communities of the region are divided on the question of whether mining and its infrastructure will benefit their future generations. So much so that federal Natural Resources Minister Wilkinson calls the Ring of Fire, quote, a particularly challenging space. So today I want to think a little broader about how the impact assessment reference ruling may reverberate its possible effects on the regional assessment in the Ring of Fire region, and its reverberations through the boreal peatlands, its impact on climate stability, and thus its reverberations through generations to come. And I'm going to focus on two important innovations that the Impact Assessment Act brought in that I was watching when it came into effect in 2019. And these are not directly touched on in the ruling, but I think it's interesting to consider how they might be affected in its aftermath. So the first is that the Impact Assessment Act contained highly anticipated provisions facilitating the ability of federal authorities to conduct an impact assessment with a, quote, partner jurisdiction. So this is intended to include the provinces, of course, but the novel piece of this was that it was the definition of partner jurisdiction opened the door just a little bit to the idea that an Indigenous governing body could maybe someday constitute one of these partner jurisdictions. These provisions were responsive to recommendations made by the Liberals' own expert panel set up in 2017 to rethink environmental governance. And the panel stated, quote, should Indigenous groups without modern treaties wish to undertake their own impact assessment processes, they should be able to do so, and cooperation agreements with these groups should be negotiated. Federal impact assessment governance structures and processes should support Indigenous jurisdiction. And this is going a little bit in the lines of what Professor Curran has described in terms of a massive trend over recent years towards Indigenous-led impact assessment. So ultimately, Section 114(1)(e) of the new Act outlines that if authorized by regulations, the minister may enter into agreements with any Indigenous governing body, even those that don't have self-governing powers under a modern treaty, to implement an impact assessment. These were formerly referred to as the Indigenous Cooperation Regs, and I see they're now apparently going to be called the co-administration agreements. They seem to be stalled at the discussion paper stage. The second innovation that I wanted to talk about, exciting new provisions in the Impact Assessment Act for me, were those that allowed for regional assessments. So a regional assessment is an environmental study conducted in places where there are multiple existing or anticipated projects or developments in a concentrated geographic area. So I was going to mention the Yehi decision. Deb has already done that for us. People will be attuned to the fact that obviously the cumulative impacts from multiple industrial projects on treaty rights is an important issue. So for me and my students, the Ring of Fire area, which is predicted to host potentially a dozen mines within the next 20 years, looks like a perfect opportunity to try out the new provisions on regional assessments, given the way the proposed new roads to the region are meant to open up possibilities for, as I said, multiple new mines and developments in a previously undisturbed landscape. So I tasked some of the clinic students in writing a request to the minister to establish a regional assessment. And I said, remember, it can't be just about why a regional assessment makes sense in the Ring of Fire. It has to be about why the feds should do one. And so they're good students. And so what they wanted to say was, of course, it's good planning to look at all of the ecological, social, cultural impacts together cumulatively. They wanted to say it would be short-sighted to make such a high consequence decision without a wide-ranging, forward-looking, sustainability-informed inquiry. But since they're good students, what they actually wrote was, quote, the anticipated developments have the potential to cause adverse effects on the climate, on fish and fish habitat, migratory birds, species at risk, and Indigenous peoples. In other words, even before the Impact Assessment Act reference, we knew that for the Act to apply and for the minister to be persuaded, the probable effects in question had to be adverse effects within federal jurisdiction. Now, a community like Nishnantika wants a regional assessment because they hope it can provide some of these big picture impacts before individual projects start being approved, and in this case, before all season roads begin to be approved. And unfortunately, the agency's first, this is the Impact Assessment Agency's first attempt at crafting a terms of reference for that regional assessment was a failure, to be blunt. They pitched it as a unilateral undertaking of the Crown to assess the impacts of mining on lands and waters solely occupied by and stewarded by Indigenous peoples. To pitch that as a unilateral undertaking of the Crown was roundly and I think rightfully rejected by First Nations in the region and in fact all major environmental organizations. So 6 months later, January 2022, Minister Guilbeault agreed in a meeting with the chiefs in Thunder Bay that the regional assessment would be, quote, co-led with an Indigenous governing body made up of the affected First Nations in Treaty Number 9. Now, however, 2 years later, the terms of reference for that regional assessment is still not even close to being finalized. And the individual impact assessments for the proposed roads, while they're also delayed, are moving basically at warp speed in comparison to the regional assessment. So what is the impact of the decision when it was kind of dropped into the mess, this same mess last fall? I was going to use many of the same examples as Anna, so I won't give you those. The example of a mine and the difficulty that the majority judgment has in reasoning through how to deal with those effects, I think Anna described very well. So to remind you, the basic thing she's outlined where the activity falls under provincial jurisdiction, but causes impacts to areas under federal heads of power, Parliament's jurisdiction is said to be narrower than it would be if the activity fell under a federal jurisdiction. So there is this varying scope in terms of Parliament's authority to regulate. Further, as Anna said, because of the focus on decision-making, those decision-making points within the Act, some people will say that regional assessments are not at all impacted by the reference case. In fact, the minister's interim guidance, which is intended to span what they call the short distance between the Supreme Court ruling and the planned amendments to the Act, state that the 3 regional assessments that are already underway may proceed as they, quote, do not involve decision-making. So here's the real crux of it. The Treaty 9 First Nations that shot down the legitimacy of that initial terms of reference for the regional assessment in the Ring of Fire did so on the basis that they said there was no world in which Canada could legitimately exercise exclusive decision-making authority over their lands and waters. In the Anishinaabe legal tradition, knowledge of the land and the authority to govern it must go together. For example, when the Premier of Ontario famously declared that he would mine the Ring of Fire, even if he had to drive the bulldozer himself, the Northern chiefs just chuckled, joking that his bulldozer would just sink in the muskeg anyway. So the litigation filed last May by the Treaty 9 First Nations, 10 Treaty 9 First Nations, makes the case very explicitly that the treaty was an agreement to share the land and not an agreement to cede or surrender governing authority. Co-jurisdiction, the nations say, is what it was actually agreed to, and co-jurisdiction remains in effect today. So this is where things get slightly complicated. The Act sets up a scheme in which the results of a regional assessment are factored into subsequent decision-making. So as Anna said, let's say the regional assessment includes a study that makes predictions about the extent to which a new all-season road will increase the risk of gender-based violence against Indigenous women and girls. That data is then meant to be factored into the public interest determination made by the minister in subsequent project level impact assessment decisions, such as for the roads. That is, instead of itself being an exercise that leads into Canada making an approval in relation to any particular project, a regional assessment in the Act structure is meant to inform the federal minister's decision-making later. So why would a group of First Nations fighting in court to have their inherent jurisdiction recognized agree to co-lead a regional assessment that will feed into unilateral Crown decision-making over contested projects on their lands? These are some of the smallest, most remote, most capacity-starved First Nations in the country, suffering major infrastructure deficits like boil water advisories and social emergencies. And I think the answer to that question we can imagine is they won't agree to that. Or, you know, as Deb was saying, what would all the fuss be about? Why would it be worth it? And that gives you a clue as to why establishing the terms of reference for the regional assessment is taking so long. So just to conclude, what I am seeing in the aftermath of this decision is a tension between two of the main goals that we were chasing in the drafting of the Impact Assessment Act. The more the agency leans into the cooperation, collaboration with Indigenous authorities, in line with Minister Guilbeault's promise, which will inevitably increase the decision-making nature of the impact assessment, of the regional assessment, the more Ontario and the proponents, I think legitimately, will seek to limit the scope of the regional assessment to matters that are already considered to be squarely within federal jurisdiction. That is, the ruling has inserted a tension between pursuing cooperation with Indigenous authorities and pursuing effective, broad-ranging, forward-looking, and cohesive sustainability assessments. So whether we can reverse this will have reverberating effects through the boreal peatlands, on the stability of our climate, and across generations. Thank you.
Thank you so much, Dayna, for those very meaningful interventions on the case. I think, like many of us in the room and your students, as you mentioned, we are immediately thinking across this reference with the prior GGPPA decision, and that's the basis of Nathalie's interventions now. Thank you.
So that we didn't have to move the television, I decided to stand. I'm also the last one to speak of the panel and standing between you and your break. So I thought I would stand up to give us all a little energy. So thank you very much for the opportunity to speak with you today. I've followed this conference for a long time and I feel really privileged to be part of it today, speaking about this very important decision. So I just want to let you know that what I'm presenting on is based on a series of papers that I've been working on over the last little while, and I'm actually working on a manuscript to try to put some of that together into a book on climate change and the Constitution. I know, small task if I ever get it written. So that's what my comments today are based on. But I also wanted to give a hat tip to a number of scholars and colleagues who've written on this as well, particularly what I'm going to present on, not just my co-presenters here, but also my colleagues, particularly at Calgary, Martin Olshinsky, David Wright, Nigel Banks, that have been putting out commentary on this and for which I am also drawing upon. So what I'm going to do is very briefly offer a little bit of context building on what my colleagues have presented and really try to focus in on the link between this and the GPPA decision, but also the broader question about jurisdiction over what I like to call climate federalism, or this idea of what is the polycentric constitutional space for lawmaking on climate change. And so I'm going to give you a little bit of context and then really raise what I think are three, I decided whether to call them critiques or reflections or preoccupations. You can decide what they are at the end. So, you know, just 2 words on the context here, which I think is worth mentioning. We know that the Impact Assessment Act is the 4th in a series of environmental/impact assessment regimes in this country in the last 4 to 5 decades. And the iterations of these acts have reflected the increasing complexity of decision-making around sustainability and environmental issues, and have tried to move towards more integrated decision-making. And also, you know, reflecting explicitly the context of the climate crisis that we're in. And so, you know, I think it's worth noting as we talk about this decision, and sorry, I just went ahead to the next screen, that, you know, we're deciding and talking about this case in the context of an urgent climate crisis that our Supreme Court told us in 2021 was existential, and it truly is. We just heard this week that the wildfire season that we experienced last summer is projected to be worse. And that really is just the tip of the proverbial iceberg, given that the experiences of climate change that we live today are really due to emissions from a couple of decades ago or more, because there's a built-in inertia in the system. So while we may want to keep our heads in the sands, and I'm going to encourage you to look for as many puns as you can in this talk, you know, we have to consider that in light of what's happening. And at the same time, just 2 days ago, there was a really important decision that joins a number of other decisions globally in different courts around the world on the obligation of governments to do more faster to deal with climate change. So I want to look at that, today's decision against this backdrop and really raise these 3 points of reflection, as I've said. So first of all, and my colleagues haven't touched on this, so I do want to spend a few minutes on it. I found it really interesting that the majority's interpretations of definition in this case were really narrow and literal and formalistic. And I think that suggests an unnecessarily myopic focus on the trees to the exclusion perhaps of the broader forest, which I think is problematic, not only for this decision and its implications, but also because environmental legislation generally is worded broadly. And so are we looking at putting into question 50 years of environmental jurisprudence that has incidentally been upheld by the Supreme Court in more than one decision? So I'll come back to that. Then this other question of the gap. We're told in this decision that Parliament doesn't have jurisdiction, at least in the way it was worded here, over interprovincial effects. And so I think that raises some really interesting questions about potential constitutional gaps or legislative vacuums in this context, which I will turn to after. And then lastly, there was a tone in this decision of scolding or perhaps chastising the Canadian government for not having federal government for not having done enough to justify jurisdiction over considerations of greenhouse gas emissions in this decision. And so I want to talk about that elephant in the room really and look at what the smoky haze of jurisdiction over greenhouse gas emissions is in this country, something that I'm mildly obsessed about. So turning to this first question, which is I think one of the most interesting parts of this decision is you look at the definition on the screen here of effects within federal jurisdiction. And as my colleagues alluded to, the court took a serious issue with this wording, and in particular, the very broad language used to describe, for instance, a change to fish and fish habitat or a change to effects from one activity in one province to impacts in another province, what they call interprovincial effects, changes to the conditions of Indigenous peoples, and even the definition of environment. And so maybe you just read this decision in silo, you'd think, well, that makes sense. These are pretty broad definitions. But for somebody who's worked in this space for a number of years, if you were to look at the definitions of environment, natural environment, adverse effect, contaminants in jurisprudence, both provincially and federally in that legislation, you'd see that this is how environmental laws are written. You would also see that the Supreme Court has condoned this approach in its approach to statutory interpretation in a number of decisions. So we can look to some of the decisions that were one of the decisions in particular that was discussed in the dissent, but that really explained that there's a purposive and an intentional reason why we use broad language in environmental statutes. And that's because it's hard to predict what the impacts are going to be. And so legislators use broad language. And then there's an assumption that the legislators had a bona fide intention to stay within their lanes and apply that in a way that isn't trivial. And so I think that the tone of this decision here hints, and again, one of my other colleagues at U Ottawa, Paul Daly's written about this, really hints at a tone of perhaps bad faith or mistrust that I think permeates the majority's reasons here. And I think potentially diminishes the value of the expertise of the executive branch in applying the Impact Assessment Act. So I think this is something that I'll come back to when I speak about GHG emissions and jurisdiction there. And also conspicuously, there's a decision of the Supreme Court from 2013 that's not mentioned by either the majority or the dissent in this case. They do mention Canadian Pacific, which was a foundational decision which talked about the broad language in environmental law and the fact, again, that not only is this to be expected, but it is condoned as purposive and intentional because that is the only way that, that the federal government and the provincial governments can achieve their objectives. But Castonguay blasting, which focused focused entirely on this issue was missing from the decision, which I found interesting. So, so wherefore art thou, cast on daily fasting? How come it wasn't mentioned? And more importantly, if we take a step back from this, what does this mean? Was this intentional on the part of the majority and their reasons? Was this meant to signal that we have to go back and look at environmental legislation more broadly and rethink how we draft it? I don't think so personally. I think that would be something that might raise the absurdity principle, which was referred to by the dissent. And, again, referencing back to the bona fide intention of both levels of government in applying their legislation. So I think the preferred approach is the one that we saw in the dissent, which again, two versions of the presumption of constitutionality. I like the one that dissent spoke to, which again refers back to this posture of respect and presumed good faith on the part of the legislatures and on the executive. So I think that's really important. And I think we have to reflect on what this means more broadly for environmental and climate legislation generally. And I'll just skip over some of these slides. The second point I wanted to refer to was, this potential for a gap. And referring back again to the definition of effects within federal jurisdiction, the court mentions that deems this clause, which is before you, the interprovincial effects clause, and notes that it captures an unlimited range of interprovincial environmental changes. Sure, if you read it literally, it does. But again, if you go back to read environmental statutes at the provincial or federal level, generally, they all would. So, I think the court was particularly preoccupied with what my colleagues mentioned, which is this elephant in the room of, can the federal government say no to a project predominantly within a province that might hinder Canada's ability to meet its climate targets on climate change? And so there was a set of paragraphs in the decision that again scolded the Canadian AG for not having made an argument that clarified the purported jurisdiction over GHG emissions in the Impact Assessment Act, and reminded us that that court had only 2 years back told us that the National Concern Branch justified the federal government making law to establish minimum national standards of carbon pricing, but did not convey plenary or comprehensive jurisdiction over greenhouse gas emissions. We know that, of course not. And so I think that what it raises, for me, are a whole number of questions about, well, if interprovincial effects are not within Parliament's jurisdiction, where are they? Where do they belong? Because I think by definition, they don't belong in the provincial column. And so, and I think this actually ties back very nicely to Deborah's presentation and the triple aspect, which I love. We all wrote that down. So, what does this mean, and what would have made this provision constitutionally compliant? Which I think is interesting. And in fact, the majority reasons, maybe to be more positive, put out an olive branch to say, well, the door is not closed on jurisdiction under national concern for greenhouse gas emissions considerations. Council didn't do its work, didn't present the argument, neither oral or written submissions, and so we're left with a question mark. We're told that we know under POG national concern that Parliament has jurisdiction over preventing marine pollution in Zellerbach, pollution of interprovincial rivers and interprovincial cooperatives, atomic energy, and of course in the GPPA reference, establishing minimum national standards of price stringency. And we know it's not comprehensive or plenary jurisdiction under POG, of course not. So what does that leave us? And I think that's one of the interesting questions. And in my writing on this, I will go through the updated 2.0 test. But I think for our purposes and our discussions, it's worth thinking about, is there a narrowly subscribed matter which would have, had Canada argued it, satisfied the majority here? And what would that look like? And again, I turn to some of my colleagues who've done some really good writing on this and thoughtful commentary. We've had all sorts of discussions. But extra-provincial harms of GHG emissions at a particular threshold, minimum national standards of GHG abatement stringency, perhaps, instead of pricing, because we've done a lot of work on the carbon pricing world, but pricing and emissions abatements are kind of interchangeable to some extent. So it's the tool, right? So what does that look like? And so if you do apply the updated 2.0 national concern test from the GPPA reference, what did it look like? Well, I mean, I've gone through the analysis, and I think the big question is, of course, going to be on scale of impact. I think the rest of the test is probably manageable. Scale of impact is going to be tricky, likely based on how the court is going to take and do this balancing this balancing and proportionality exercise that it introduced into the test in the GPPA reference. And one of the things that I've been trying to think about is, you know, in that weighing exercise that the court introduced is, you know, how much do we weigh? And I know where I land on this, but to what extent do we weigh the existential, irreversible, urgent nature of the climate threat, especially when we're nearing potential tipping points that are going to lock us into paths of no return? So when we're deciding on whether to approve a project that will lock in emissions for 20, 30 years on a trajectory that's going to be very difficult to change in light of capital investments and decisions, you know, can we factor that in, and how do we make that balancing act? And I do also, you know, bring us back to the double aspect doctrine, the, you know, current interpretation of the paramountcy doctrine. And, you know, we need to think about, again, in my view, and as, you know, Jean Leclerc said last year, I think in this world of inverted subsidiarity, perhaps there is space for, you know, he argued for concurrent jurisdiction. I would say whether it's concurrent or shared, that there is the constitutional space for all levels of government to be acting in this space. So where does that leave us to conclude? I just want to remind everybody that, of course, the Impact Assessment Act is not the primary tool for regulating climate change or greenhouse gas emissions at all. And in fact, if this was struck out, and if in the amendments that are likely to be introduced next week, I would think perhaps within a budget bill, they, you know, would, even if they were not maintained, that's not where most of the action is going to be taking place. We know that there are more challenges coming. We're in maybe round 2 of the constitutional boxing match between the provinces and the federal government. And so, you know, the criminal law power, Senator Stewart talked about it last conference cases, I think, but, you know, that's going to be another very interesting question. To what extent can the government rely on its criminal law power to enact, you know, climate federal policy, whether it's the clean energy regulations, the emissions cap from oil and gas, or other regulations? We know they're going to be relying on that. The question is, with the plastics decision, to what extent is the court going to do it? But to conclude, I mean, my sense is that the tone of this decision is unfortunate. I think there's, it sends the wrong signals in light of where we are today, leaves potentially a gap in you know, our ability to address these fundamental issues. And, you know, I ask you some questions as we conclude. You know, is it conceivable that Parliament could be constitutionally incapable of ensuring it meets its national climate targets? Interesting question. And what happens if a court, and, you know, to bring it back to climate litigation, holds the federal government to account for lowering emissions, perhaps under a charter interpretation, but Parliament's constitutionally incapable of considering GHG emissions for major projects? So I leave you with those thoughts and in the smoky haze of GHG emissions, and thank you very much.
So thank you so much, Nathalie. That was such a big contribution to our understanding of the reference. I think all of these papers are already giving us so much to think about with respect to this decision, and I'm looking forward to the final iterations of the papers. Might anyone in the room have a question for our panel or any of our panelists? Right here, thank you. Oh, we have a microphone. And if you wouldn't mind introducing yourself as well, that would be lovely.
Hi, my name is Rohan. I'm a JD MES student at Osgoode. My question is that the court seems to put a lot of emphasis on federalism and respecting the division of powers. But one of the things that was affirmed in the greenhouse gas case was Wagner changed the national concern component, in which the provinces have to show an incapability and historical approach to treating the problem. But right now we're seeing the province is childishly rebelling against Ottawa for every single climate action. So given those circumstances that were established in greenhouse, isn't it almost inconsistent for the court to then say you have to respect the division of powers when when the provinces themselves haven't been when there's been varying treatments of environmental assessment, which are key to climate action, which the court also acknowledged in greenhouse as the greatest existential threat, in which it also recognized the IPCC science as well. It just seemed a little bit inconsistent.
Sure, I can give a quick answer to that, which is that I think that the decision, the majority wasn't saying that we couldn't justify consideration of greenhouse gas emissions in the impact assessment reference in the act under POG national concern. It was saying you didn't give us the framework, you didn't give us the argument, the evidence. So I think if they did, personally, I think it would meet the test, and certainly the provincial inability. If you use the logic from the GPA reference, there's no question that the whole point there was that, you know, if emissions in one jurisdiction go up, that impacts, you know, somebody else has to make up the fall or the gap, or we don't meet our targets, both of which are outside of that one province's interest. So I think the provincial inability test is not the most difficult one in this case. I think it's really going to be the scale of impact.
And I have one more, if that's okay.
I want to answer that one too.
Okay.
Quickly, the provinces are definitely playing cheeky monkey. I'm also intervening in the Mather Youth Climate case against Ontario for its weak targets. And I know what council says in a hearing isn't necessarily, anyways. In the hearing, Ontario argued that it didn't need to have an ambitious climate target because Canada could just pick up the slack. And they were one of the more vocal opponents of Canada asserting jurisdiction over GHGs in the Impact Assessment Act reference. So there's definitely a little both sides of the mouth going on that points to provincial inability.
Did you have a second short
Yeah.
follow-up?
Yeah, and my second question is, given that almost every project touches federal jurisdiction, whether it's migratory birds or whether it's indigenous lands or species at risk, isn't it technically that even though there's that national concern, national interest component, the federal government can basically intervene in almost every project anyway, which could increase the litigation by the provinces each time?
I mean, then the national concern applies to would be the GHG hook. So what the court said is that
I meant the public interest impact assessment.
I can try to. I think the question is thresholds.
Yeah.
And I think one of the issues that the court, you know, hinted at several times is that if you had the adjective significant, or if you had qualified the thresholds, you know, important, serious, significant somehow, that would have more clearly been linked to the decision making. I mean, it's in there. If you look, it's actually really in there, but it wasn't sufficiently explicit in the public interest determination. And again, a really reductionist reading, a very formalistic reading of language, because they use the word sustainability in a paragraph, but they didn't embed thresholds earlier on. So, you know, I have a different view of than the majority on this in terms of their interpretation, but I think that it's a question of thresholds and making them as explicitly tied to decision making that would have perhaps ended up in a different result.
Thank you. We have time for one more question. Tamsin?
Hi there, just for the entire panel, I suppose. So I'm reading paragraph 128, the impact assessment decision, which was touched on by one of our panelists about the possibly arbitrary distinction between resources and activities. And at paragraph 128, specifically the court urging specificity and precision with respect to environmental legislation side by side with the decision that our most recent speaker spoke of at paragraph 9 about the expansive approach. So it's clear that the court within 10 years seems to have switched the register here. I'm just trying to put my litigator cap on. I should have introduced myself. Tanzim Rashid. I graduated in June of last year, and I'm litigating at Lax O'Sullivan, potentially some cases with some of you, given who we represent. And so I'm trying to understand from the litigator's perspective, if they would say that because the 2013 decision was grounded in the perspective of provincial jurisdiction, that the dicta here would just be where it's provincial environmental jurisdiction as opposed to federal environmental, or if that's a distinction without a difference from your perspectives.
Deb, anything from you online? No? Okay.
Well, I guess that was something I talked about. I mean, I think the principles that are shared in Canadian Pacific and Castonguay blasting about interpretation is replicated. You're right, they're both about provincial laws, but the reasoning is really generalizable because they're just talking about the purpose of using broad language. And then the slide that I skipped over really quickly was a slide in the CBC case from I think the 70s with Betts talking about it in the non-environmental context. So just again stating that most statutes are worded so broadly that if you wanted to, you could find a way to apply them in a way that was ultra virus. But we don't do that because we presume bona fide good faith on the basis of both levels of government, both in their drafting and in their implementation. So I personally think it's transferable, but you know, that's my view.
I guess the reason I asked,
Oh,
I don't want to extend it too far. Given my understanding of this area of law, there's some say that because it's not provincial, it is okay to have expansive interpretations to talk down federal. That might not be, that's something that I'm just talking about. But if it's the case, there is no additional principle. Let's see as it's distinction.
I just have one quick to add to that question from our online chat. And I know there's viewing parties at faculties across the country. So welcome and the warmest hello. You are here with us in person and we're just so grateful. So if anyone has a 1-minute response, if not, we'll just be thinking about this question, which is this is a question from an international human rights law and environmental scholar. And they wanted to know what kind of impact you see this decision as having on Canada's potential liability for transboundary pollution and whether this might lower our due diligence threshold. So I don't know if anyone has a 30-second bite that wants to take that bite, or maybe we can chat about it. Anna, you looked intrigued.
No, I am intrigued, but I would need to think about that.
Okay, so I know it's almost time. So Kate this morning in our year in review noted that in the past year's decisions, a very confident court. And I was just recently at the University of Virginia on at a symposium on judicial rhetoric, where there are a number of papers in cross-constitutional law on these new strategies of judicial aggrandizement was the term. And I was thinking about a court that is feeling insulated. And then I was hearing throughout all of these presentations, languages about time, existential crisis, that's even the court's own terms that seemed not present here, running out of time, tipping points, generations that should be reflected upon. And I was thinking about maybe some of the pernicious qualities of judicial aggrandizement that were leading to a court feeling insulated from this problem of climate crisis that we are facing. So this was a fantastic set of papers. I welcome you to our coffee break, and we have 2 split sessions coming up at about 11:20. So thank you, and looking forward to discussions throughout the day. 11:30. Thank you.